You ready to go?
Yeah.
All right. And 3, 2, 1.
Hi, this is Attorney Joe Fieschko, and today I want to talk to you about laws regarding unpaid overtime claims and unpaid wage claims. Um, this is an area of the law that not very many lawyers know about. Frankly, many of the things I do, other people do. Personal injury cases, workers' compensation cases, Social Security disability, bankruptcy, wills and estates. A lot of people do those things. With unpaid wages and unpaid overtime claims, there's very few lawyers that do them. And if I can be frank with you, there's very few lawyers that know about them. So here's the law for the next half an hour. The first thing to know is you have a legal right to be paid for the time that you work and also to be paid overtime wages if you work over 40 hours in a work week. This is not a union rule. This is not a custom. It is the law. And there are two similar laws that apply. One is called the Fair Labor Standards Act. That's the federal law. And we also have a state law that's very similar, although there are some important differences I'll get into. And that's called the Pennsylvania Minimum Wage Act. The essence of both of them is pretty simple. The first provision regards minimum wage. As I'm doing this program, it is still $7.25 per hour. There's really very few cases. I never had a case where somebody was making less than that and we had to sue for that. The cases all come in for unpaid wages where you are working longer hours than you're being paid for, or cases where you're not being paid overtime. And the overtime law is rather simple. You get time and a half for any hour worked in excess of 40 in a work week. There's no provision for getting extra money on Sunday. There is nothing for holidays. There's nothing for shift differentials, working at night, things like that. These are really simple concepts. But we find that employers violate them, sometimes intentionally, sometimes unintentionally. Let's get into it. A lot of people don't understand that even if you are a salaried person, you're often entitled to overtime wages. I am on a kind of a, I guess you'd call it a blog or a website where different lawyers talk about different subjects. And I find that a lot of them think, for example, if you put your secretary on salary, let's say you pay her a good salary of $52,000 a year, that you can have them work whatever hours you want them to work. Not true. Even on a salary, unless you're what's called an exempt employee, which I'll get into on the next page, you have to pay that person overtime. So I had a case a couple of years ago where I had a maintenance worker at one of the local Catholic parishes, and the pastor had him working 70 hours a week. And he said, well, I can make you work as long as I want to because you're on salary. Completely wrong. We had to sue the diocese, and they actually, after discovery, wound up paying them because if you're working over 40 hours a week, unless you're what's called an exempt employee, they have to pay time and a half overtime. So, what are some of the exemptions? There's three major exemptions that we see all the time: the professional exemption, the executive exemption, and the administrative exemption. They have all three of them have a similar situation where the employer must show that the employee meets both the duties test, as it's called, and the salary basis test. So for the professional exemption, the duties involve the employee has an advanced degree. Now, an advanced degree is more than a bachelor's. Usually we're talking about doctors or lawyers, something like that. So you have to use an advanced degree. You have to use it in your job. So, for example, I had a case in New Mexico one time where I was working with a young lawyer. He was the local counsel. And when he was initially hired by a law firm, they had him put on a hazmat suit, and he was help cleaning a hazmat site. He would not have been an exempt employee because that was not using his law degree. So you have to have an advanced degree and use it. That's the duty. And you have to have a salary. And I didn't understand what a salary was until I started doing this work. But a salary is a fixed amount of money that you get paid every week, no matter how little you work. If you just work 1 day a week, you have to get that salary. And right now, that salary is at $684 per week. We are reasonably sure that's going to go to $1,059 per week in the near future. $684 a week comes out to a person making $35,568 per year. The increased $1,059 salary requirement would be a person making $55,068 per year. Let me tell you why that's important. We'll get into the executive exemption in a second. And that's the one where you're the boss. That's why a foreman in a coal mine doesn't make overtime, but the coal miner does. Especially in the fast food industry. A lot of times the fast food chain will have the assistant managers, and sometimes they're making $35,000, $36,000 a year. Well, because they're a boss, they meet the executive duties portion of the test, and the person making $35,000 per year then, sometimes they work 70 hours a week. So on a per hour basis, the assistant managers are making less than the kids working at the counter. So the whole idea of raising it from $35,000 to $55,000 as a minimum basis, the employer can't turn to these assistant managers anymore and say, well, you're on a salary and you don't get overtime, so we can work you and you can make less than the kid at the counter. So that goes into the executive exemption. That's a clearly defined exemption also. You have to have 2 full-time people working, and you are supervising them. So that's the duties basis. And it can be in any way. For example, a few years ago, a police chief of one of the smaller police departments around called me and said, am I entitled to overtime? And I said, well, how many cops do you have underneath them? And he said 4, but they're part-time. I said, well, what's part-time? He goes, they work about 25 hours. Well, if you added up those 4 police officers, they came to over more than 2 full-time people underneath them. So I said, what's your salary? He was over the $684 per week. And I said, you're an exempt employee. I can't help you. You're not entitled to overtime. And by the way, with this salary, and this is kind of important, it is a guarantee, as I said. Even if you work 1 day a week, you get that salary. And they can't dock you. In rare occasions, they can dock you. But for example, I had an employer that if the manager had to go off to a doctor's appointment, they would dock her. Can't do that. If you are regular getting docked, you are not making a salary, and she actually was entitled to overtime when we recovered the overtime for them. So that's the professional, then the executive. The third one is administrative. That is a little more difficult to describe than the first two. But the legal definition is somebody that's working in the general business of an employer and regularly exercises discretion and independent judgment. What we're talking about there is somebody like a insurance adjuster. You know, they work for Erie Insurance, and their job is to exercise discretion and independent judgment. If they are paid on a salary basis, which frankly most adjusters are, then they're going to be exempt. There are some other exemptions. Oh, here's a good one. The Motor Carriers Act exemption. The Motor Carriers Act exemption is interesting for this reason. The idea of the Motor Carriers Act exemption is to concentrate on people that drive tractor trailers for a living. As all of you know, working overtime, if you're driving a tractor trailer, is illegal. The Motor Carriers Act says how many hours you can work per week, and that's it. Then you have to turn off the truck and go sleep somewhere. It's illegal to work overtime. So the idea is if it's illegal to work overtime, obviously we can't require time and a half overtime. The Motor Carriers Act applies to any employee that is involved in the safety of interstate commerce. And that would include 4 categories. There's the driver. There is often a guy sitting next to him called a driver's helper. There's a loader. A loader is a guy that loads the truck and secures the load and balances the load, because obviously you have an unbalanced load that creates a safety problem. And the fourth one is that of a mechanic. Sometimes we have had close cases regarding that. A few years ago, I had a group of people that worked in a warehouse, and the trucks were also owned by the employer, and they weren't paying their warehousemen overtime. And they said that's because they're loaders. Well, I happen to know that that particular company had a driver and a driver's helper. So I said, well, when these trucks pull up and they got a driver and a driver's helper, are those guys just sitting around while the trucks get loaded? Well, it turns out under cross-examination, they don't. The warehousemen put it on the dock, and then the driver and the driver helpers were the one that loaded and balanced and secured the load. So we got all the warehousemen overtime because they weren't loaders. Sometimes under one of the exemptions, and we're talking about the professional, executive, or administrative exemption, an employer will not pay on a salary basis. And I had a series of extremely large cases throughout my career that involved this question. The first one I had was on the Exxon Valdez oil spill. And Exxon sent a bunch of adjusters up to adjust all the claims for primarily fishermen that had been shut down because of the oil spill. They paid these guys $35 an hour. They worked about 70 hours a week, and they didn't pay them overtime. Well, normally they are exercising discretion and independent judgment, and normally they pay them a salary. But in this case, they're paying them by the hour, so we won that case, and they had to pay all the adjusters on the Exxon Valdez. That was a group of people called catastrophe adjusters. And we don't really see those people here in Pennsylvania because we don't have catastrophes. But much of the rest of the country is one big catastrophe. And in Florida, they always get hurricanes. Um, and in other areas, they get fires and all those kinds of things. So, what was happening was during that period of time, these same catastrophe adjusters would keep coming back because the employers kept making the same mistake. So the people that worked on the Exxon Valdez, their next project was in New Mexico because the federal government was trying to do a controlled burn in New Mexico to prevent fires, but they did it in a high wind. So they burnt down most of the town of Los Alamos, which is famous for developing the nuclear weapon, and a bunch of other cities. So again, they had a number of adjusters. They were paying them by the hour. They weren't paying them overtime. So again, we were able to recover those people overtime wages the second time. They went on to California and worked for Farmers Insurance because there were too many mold claims that Farmers was getting at the time. They made the same darn mistake. We won again against Farmers. But the biggest one was in the BP Horizon oil spill. And that one, well, to give you an idea, for the Exxon Valdez, we had about 72 adjusters. For the BP Horizon, there's over 2,000 adjusters. So we brought a class action down in New Orleans, and you have to opt into these cases, and 1,600 of the 2,000 opted in, and we recovered $14.9 million for those guys and gals. So these cases can be quite large, and these are basic mistakes that an employer can make. I know that in all these cases, I don't think that the employer was doing it intentionally, but they were in violation of the law. And when you violate the law, you can be sued and you have to pay for the damages. The fourth thing I want to talk about is a difference between federal law and state law. And I had two substantial cases in the state of Pennsylvania. One was against Frito-Lay Corporation. The other was against the KAPS, K-A-P-P-S company. They are a lawn care company. And they made the same mistake. And I'll tell you what it is. Their employees were not exempt under the duties basis test. The Frito-Lay guys were driving trucks under 10,000 pounds, so they weren't under the Motor Carriers Act. The KAPS people were just, fertilizing lawns and spreading weed killer on lawns. So under the duties basis, they were entitled to overtime. They were being paid on a salary basis, and they were actually being paid overtime, but under the wrong formula. And here's where I'll give you an example. Let's use simple mathematics. Let's say that one of these workers was making $600 a week and working 60 hours per week. Under the federal formula, if you're working 60 hours a week and making $600 an hour or $600 a week, then you're making $10 an hour. 600 divided by 60. They say that you can pay that person overtime of $5. That would be the half for any hour worked in excess of 40. So in that example, you're working 20 hours overtime times $5. You get $100 a week overtime. That's fine under federal law. Under state law, that's not the formula. Under state law, you work 600 or you earn $600 a week. You work 60 hours. They say that $600 was full payment for the first 40 hours. So again, using that mathematics, you are paid $15 an hour for the first 40, but you weren't paid a dime for the extra 20 hours. So you're not just owed the half, you're owed the time and a half. So you're owed $15 an hour because that is the regular rate, plus the half of $7.50, so it's $22.50 an hour. And if you're working that extra 20 hours, the overtime is $450. So you're talking about a difference between $100 a week overtime and $450 a week overtime, which you can see is quite substantial, and we won both of those cases. The next topic I want to talk about is what's called time worked. And I can give you a really good example of a case we had a few years ago involving what's called time worked, because a lot of people don't understand what working is. At the airport, the county employs, I think it was about 10 canine officers, and they were very strict. They said, you guys work 40 hours, period. So they would bring the dog out, they'd work the 40 hours, they'd go home. Well, the problem was the county wasn't paying these guys to feed the dog, wash the dog, take the dog for a walk, take him out to go to the bathroom, take him to the vet. None of that was being paid. And I think you can understand these dogs aren't pets. They're almost like machines. So we sued the county, and indeed they had to pay them for all that time worked. I had a young fellow that worked for a guy that did a hunting show on one of the channels. When you're flipping around, you see these hunting shows, and they're kind of small operations. And they're always done on location because you have to go to Montana to shoot bighorn deer, and you have to go to these various places to hunt the various game. So when you are working away from home, your travel time is compensable, and you're almost on the clock for most of your waking hours. So a lot of times traveling employees are not paid in full. And sometimes people just are in violation of the law. And usually these are smaller cases, and they know darn well that they're in violation. Right now I have a person who is a janitor for a fella, and she goes to the various areas to do her job. And she works about 70 hours a week. And the guy's been paying her 40 hours a week and deducting wages, et cetera, et cetera. And then he's got this separate accountant to pay her the extra 30 hours a week, and he doesn't deduct taxes, and he doesn't pay her overtime. He knows darn well he's in violation, and this is a recent case, so when she gives me the green light, I can pull the trigger, and this guy will have to pay. One of the ways that some employers try to dodge paying overtime is by calling their employees independent contractors. And there are independent contractors and there are employees, and it's fairly easy to tell the difference. I'll give you two examples. My secretary would be an employee. If I need a new roof on my house, I'll hire a roofer, and he will be an independent contractor. Now, what are the differences? Well, first of all, I have the right to control the manner of work of my secretary, not the roofer. I don't know a darn thing about roofing. Secondly, an independent contractor normally will have investments in the equipment and materials needed. He'll bring the shingles, he'll bring his tools. My secretary just sits down and uses the computer. Third, an independent contractor usually has a specific skill. He's got a specific skill, roofing. The next one, The employee normally works as an integral part of the entity's business. So obviously, a good secretary is a key to a law firm. She's an integral part to my business, whereas the roofer is not an integral part of my business. I'm not in the roofing business. The permanence of the work relationship. My secretary, who's actually my wife in this instance, frankly, she's worked for me for 40 years. Well, actually, we both worked for the corporation. But that's a permanent relationship. Obviously, when the roofer gets done with the roof, he goes home, and that's that. So you can see the difference. Areas where this is commonly abused, home health care workers are normally employees. They're usually paid as independent contractors. But when you boil it down, and we had a case on this, they are employees, and we won that. The construction industry is so rife with this abuse that the state of Pennsylvania actually passed a law called the Independent Contractor Misclassification Act that provides for criminal sanctions to employers that call their employees independent contractors. Well, why did they call people independent contractors? Save money. You don't have to pay workers' comp insurance. If an independent contractor gets injured, tough luck for him. And the employer saves the money paying workers' comp insurance. They don't have to pay for unemployment insurance. They don't have to pay Social Security tax. They don't have to pay withholding tax. They don't have to pay overtime. Sometimes they have to pay their employees health insurance, holidays, or vacation based on some agreement. Again, independent contractors work outside of that. So the employer saves a ton of money by misclassifying the person as an independent contractor. And if you're in such a position and you're working more than 40 hours a week, you probably are entitled to overtime. A few last things. The statute of limitations under the Fair Labor Standards Act, it's a 2-year statute of limitations, and 3 years if the court determines it was an intentional violation. The way it works, and frankly, what normally happens is people are a bit reluctant to bring these lawsuits against their employers until they quit, until they retire or go off the job. There are sanctions for discrimination if a person brings a lawsuit, but obviously it's uncomfortable. Most people don't want to do it while they're working, and that's understandable. So if you stop working, every day you don't file the lawsuit, you lose money because it's what's called a rolling statute of limitations. So if you wait for 3 weeks after you stop working, well, then that's 3 weeks of overtime you just lost because of the 2 or 3 year statute of limitations. The Pennsylvania Minimum Wage Act has a 3-year statute of limitations. So that's more generous. Also, these are what are called statutes. And the statutes provide for more damages than normal. And I'll give you an example. If I'm representing a client in a workers' compensation case or a personal injury action, at the end of the case, normally you get a percentage of the settlement, 20% on workers' comp, usually a third on personal injury cases, and that comes out of the client. The Pennsylvania Minimum Wage Act and the Fair Labor Standards Act say the employer has to pay attorney's fees based on the hours that the attorney puts in. Also, under the Fair Labor Standards Act, there's what are called liquidated damages. So let's say you're owed $20,000 in overtime. Liquidated damages means you're owed $40,000. So there are these additional things in the statute that you normally don't see that include attorney's fees, liquidated damages. Under the Pennsylvania Minimum Wage Act, they don't have the liquidated damages, but they have 25% interest. So those are all differences. So this has been Attorney Joe Fieschko. If you think you're not being properly paid, give me a call. I will let you know if you are or not under the law, and that's free. And my number is 1-800-242-2412. Thanks for listening.
All right. Stop that.
Good.